Attorney, help us understand why the doctrine of operative fact does not apply in this case, which essentially states that even while the law or the Supreme Court declares it as null and void, the past actions done in good faith may still be considered valid.
Precisely. It was not done in good faith. There was a deliberate act on the part of the House to sit on valid impeachment complaints filed by citizens and endorsed by members of the House. And worse, those who endorsed these 3 impeachment complaints filed by citizens later signed the 4th impeachment complaint. That's another technicality. You see, we would not have any problem if the House just followed strictly what is provided in the Constitution and in the Francisco ruling. Had they been in good faith, then that Francisco ruling would have been followed, and maybe by this time, Senate is already conducting a trial.
But it's so hard, right, Attorney? When you're arguing things like good faith or bad faith, faith is something intangible. And if this is procedural indeed, then how do we, argue it? Because it's something that, like it's so affected by personal biases, etc.
It can be good faith or bad faith can be seen in the sequence of events. All we have to do is examine the facts. And we can see here a deliberate avoidance of the constitutional 1-year bar rule. Don't violate the Constitution. That's basic. And there was a deliberate avoidance of the Francisco ruling. To make it simple, had they followed the Francisco ruling, all they had to do is that when the first impeachment complaint was filed on December 2, 2024, they should have included that in the order of business right away. The Secretary General has no discretion to sit on it. But on the contrary, based on the constitutional provision, the Secretary General is mandated to immediately refer it to the Speaker and to place it in the order of business.
But it did comply. There were 10 calendar days.
Session days.
10 session days. Even if there was bad faith, let's just say it complied with what the rules say.
No, says, because there were 19 days, there were 19 opportunities for the House to act on it. But what happened was that on the last day, on the 10th session day, February 5, 2025, the Secretary General included all 4 in the order of business, additional reference of business. And the Secretary General read the 4th impeachment complaint
So are
first.
you saying 19 session days?
Not 19 session days. 19 days that Congress House was there.
Oo nga po, pero they are counting session days.
No.
And the rules say session days too, right?
Yes, order of business. But if you will notice, there is such thing as additional reference of business. In fact, these impeachment complaints were included in the additional reference of business, which were taken up outside of those 10 session days, but within 90 days from December 3 up to February 5, 2025. What I'm saying lang is this, that they could have acted swiftly on the first impeachment complaint.
So are you saying that the Supreme Court decision, because other legal luminaries are saying it sets aside the Francisco precedent, it's no longer the existing rule to follow, but this new decision by the Supreme Court, which sets new conditions?
There's no inconsistency, says, because the Francisco ruling is still very valid if given that same set of facts. Now, this is another set of facts that the Supreme Court has to interpret because it has to, it's the arbiter, it has to decide. Take note. Before the Francisco ruling, there is no provision that an impeachment complaint is deemed initiated upon referral to the Committee on Justice.
Yes.
I placed that in my petition.
Right. It made this
questioned
clear.
the rules. I questioned the rules, and then the Supreme Court decided interpreted the Constitution and says it's from the filing and referral to the Committee on Justice. Nobody questioned that. Nobody said the proponents of the impeachment complaints then, so many members of Congress did not say that, hey, don't apply that to us retroactively. They did not question because they know they are lawyers. Many of them are lawyers and they know that what the Supreme Court did was right. And do you know what they did? They revised the House rules on impeachment and adopted the Francisco ruling. That's why in the House rules on impeachment, at the footnote mentioned the Francisco ruling. So what's the problem now? The Supreme Court is just interpreting a new set of facts.
Okay. Attorney Francisco, to your point, do you think the Supreme Court also considered the fact that House Secretary General Velasco also gave an interview, a TV interview at that, where he said, well, he was asked, why did you not refer this sooner? And he said, because some House members asked me to hold on because may hinahabol pa silang isa pang complaint. So things like that factored into the Supreme Court decision, you think?
Yes, you can see that in the footnotes, but that shows bad faith. And that shows that you cannot invoke good faith. And the Secretary General of the House is not even mentioned in the Constitution. He has no discretion. Even the Speaker of the House has no discretion to sit on an impeachment complaint or not to act on it. It's the House. It's the action of the plenary.
What could have been the proper process? Should they have referred all to the Justice Committee and they could put them all together into one complaint, combine all these 4 complaints? Could that...
In the Francisco ruling, there's a portion there that says that when the impeachment complaints are in the Committee on Justice, they can be consolidated.
Yes.
That's in the Francisco ruling. Although I personally disagree with that, no? Because this is first to file and referred to the Committee on Justice.
Kaso attorney, meron ding mga sham complaints di ba? Na you can be the first to file, and then initiation starts and you're stuck with a complaint that cannot prosper.
Yes, but look at it this way. The Constitution provides that a citizen may file an impeachment complaint based on grounds enumerated in the Constitution and endorsed by a member of the House of Representatives. The presumption there is that a member of the House of Representatives or many members will not endorse a sham complaint. There's a presumption of regularity there.
Well, Attorney, what happens now? Because the House of Representatives has already filed a motion for reconsideration. How likely is it for you that a unanimous ruling could be reversed? And the Senate will also be tackling this in 2 days. Can they proceed? Because there's no TRO naman from the Supreme Court.
Well, it is the right of the House of Representatives to file a motion for reconsideration. That's part of due process, no? Now, as to the Senate, I do not want to preempt what the Senate will do on Wednesday, but this is all in accordance with procedure that the House at the first instance should have followed.
If this is so, and if the motion for reconsideration is not granted, then the recourse is just to file another complaint, as the Supreme Court had indicated, next year in February. Are the dates correct? Because there's also a back and forth about the dates.
Not later than February 6, 2025, 2026. That's in the Duterte decision, if I'm not mistaken.
Correct.